Well, it's hot in Charlotte this week, but it may be getting even hotter in Raleigh on the floor of the General Assembly, where they're debating, again, more changes to the civil justice system. What I want to talk with you about today is House Bill 542, which is a wide-ranging tort reform bill, but in particular one provision that is kind of complicated and often misunderstood. It's called the bills versus paid provision. And what this does is basically make a small but very important change in the rules of evidence that allows evidence of insurance for the first time in generations to be admissible before a jury. But it's only one side of that insurance equation. It still keeps away from the jury any information about a defendant's insurance. The jury is not allowed to hear any information whether the defendant has any liability insurance that might cover that defendant's losses. But it does allow the jury to consider, in fact it compels the jury to consider whether the plaintiff has health insurance, and if so, how much the health insurance has paid. Well, what this will likely do is set up a system where a plaintiff's damages are diminished or lessened because that plaintiff happened to be responsible to get health insurance. Well, again, you may disagree, and that's fine, but that just frankly makes no sense to me. I heard somebody ask, gee, would you let a murderer have a less of a sentence if his victim happened to have life insurance? Well, that doesn't make any sense to me, but nor does it make any sense to try and measure or decrease the value of a plaintiff's claim just because that plaintiff was responsible enough to have health insurance. Well, that basically is, again, one of the many changes that are being contemplated in Raleigh. Again, from my standpoint, and you're of course free to disagree, I would love to hear from you either way, it's unnecessary, unwise, and unfair. But I thank you for listening, and I thank you for reading the newsletter, and I hope you continue to do so.